they are sitting in the house and the party outside. Can that link be severed and say we are an independent set of people, we can do what we like? That will require, Malaj, the interpretation of the 10th schedule. It requires your lordships to analyze the role of the whip, how a whip gets appointed, how he happens to be a bridge between the legislative party and the political party. And that nothing happens in the House without the political party taking a decision. Nothing happens. Well, the bill is introduced by the Treasury benches, any bill.
So is it your contention, therefore, Mr. Sibal, therefore, that unless there is a split outside the House,
yes,
within the political party,
yes,
that split cannot find recognition within the legislative party within the House? That's your...
Absolutely. That's my contention. That's the law also, Malad, and I'll demonstrate that to your lordship. That is the law. Well, what happens, Malad, I'm giving your lordships an example, Malad. A bill is introduced by the Treasury benches, a controversial bill, let's assume. Bill there in which there is no consensus. Malad, what happens? The parliamentary party, a group of members of the legislature are invited by the parliamentary party to sit outside the House in a particular room and say, this is the bill that's being introduced. What should be our position? The party decides the position. And it's articulated in the House. The legislative party by itself, dehors the party, doesn't decide what we are going to do, what you are not going to do. When a whip is going to be issued, Malad, it's issued outside the House, translated inside the House. Okay, on this, you're going to vote against the bill that has been introduced, or that you will vote in favor, or that you will abstain.
But when the 10th schedule speaks about, say, a merger, for instance, now, yes, there are very few exceptions in the 10th schedule, and it speaks of a merger.
Yes.
Ultimately, the speaker has to decide whether there is a merger. The speaker will not go into whether there was a merger outside the House, because then the speaker will be taking over the function of the Election Commission of India.
That argument is entirely on a different plane, Malad. So we're not dealing with it, and we'll interpret the paragraph 4 for your lordships also.
The speaker's remit cannot lie outside the House.
Malad, there's a problem. Supposing, all right, then let's analyze that for a minute, Malad, since your lordships have raised the issue. Malad, supposing there are 10 members of the legislative party in the House, right? And the merger has to take place of the political party. They belong, say, to the Malads, to the Samajwadi Party. Right, Malads? Now, even paragraph 4 says that there's a merger of the political party, not the merger of the legislative party.
Right.
Right? So, therefore, Samajwadi Party has to
merge. But no, if we accept your argument, that would mean that unless the Election Commission of India decides on a merger outside the House, the speaker cannot take a decision within the House, within
the Election Commission did not
whether there is a merger or not. That can't be.
No, Election Commission did not decide this issue, Malas.
How else?
Because a resolution will be passed that we have merged, and that will be informed. The Election Commission, they don't have to take a decision. They'll be informed. Majority of the members of the party will decide. They'll be informed. Once merger takes place, these eight people may say, we don't want to merge. And paragraph 4 says they need not merge. But I'll come to that later. This is a very complex issue.
Actually,
not so.
Let's have a broad now framework of the facts, because
I will, Manoj.
In fact, that was our basic problem there. Unless we have a clear perception on the facts, it's very difficult for us then to look at the law divorced from the facts.
I entirely agree. But just, Manoj, may I just your lordship, what are the issues that are going to be? I just told your lordships too.
We have to necessarily reframe the issues, because the kind of the issues which are there, which are
yeah, it's not reflective of what needs to be decided. I agree entirely. The other issue is, and that's never come up before the court, and that issue is, can a governor swear in a member of a legislative party against whom a disqualification matter is pending before the House? That's the other issue. Never come up before. What then are the powers of the governor in matters in relation to disqualification? This is not a case of a pre-poll alliance. This is not a case of a post-poll alliance. This is not a case of one political party. It is a case of people who allege that they are the party because they are a majority in the legislature. Right, Mullahs? What then are the powers, or what should be the function of the governor in matters of this nature, and how he should conduct himself? Because he also knows, because the disqualification petition is pending, Mullahs. He also knows. And if the governor does, Mullahs, swear him in as a chief minister, Mullahs, he actually topples a democratically elected government and aids in doing that because they happen to be majority in the legislature. Well, that's one of the issues that your lordships may have to consider. Then the other issue to be considered is, can a court, constitutional court, without referring the matter to the speaker in the facts and circumstances of this case, decide the matter on its own, given the fact that there are no disputed facts? We are not going to, Mullahs, place before your lordships any disputed fact. All are matters of record.
Your question is, can a constitutional court decide 10 schedule?
That's correct.
10 schedule.
Yeah, that's correct. That's correct. That's correct. Because under the 10th schedule, it is the speaker to decide, Mullahs. Correct, Mullahs? But if the proceedings, Mullahs, are imbued with illegality, and given the conduct of speakers in the past, what then should be the attitude of the court in a given matter? That's the other thing. And then, of course, lastly, Mullahs, how do you deal with an issue? And that, Mullahs, because the last question in the reference is the powers of the Election Commission. And your lordships, and that's the last question, which is the last issue your lordships will have to decide, that under paragraph 15 of the symbols order, when there is a split in the political party, it starts with that proposition that two factions have arisen pursuant to a split in the political party. Then which faction should get the symbol?
Will that arise in this case?
I'm sorry?
Will that arise here?
Yes, that's a question. That's a question. What is the role of the Election Commission in matters under the... That's part of the reference.
So under paragraph 15 of the symbols order, when two factions emerge in pursuance of a split.
Yes.
So what is the sequitur? How would you end the sentence?
Well, then what is the role of the Election Commission in deciding that matter? Should it await the decision of the Constitutional Court? Should it go ahead? Your lordships only, Mullahs, as your lordships will remember, in September said no stay. But your lordship did not say how he is going to decide it.
But that, Mr. Sibyl, is your independent challenge to the order of the Election Commission.
That's a separate issue, Mullahs.
We can't really decide.
No, that's part of the reference, Mullahs. I'm going to argue.
But
I'm going to argue, Mullahs.
Can we, how do we?
He's saying
constitutionally, the Election Commission cannot proceed. Mullahs, the split would have to happen on 21st of June. There was no whisper of a split on 21st of
Your
June.
contention that therefore the Election Commission itself cannot proceed until the Speaker has decided.
Correct. That's what your lordship said. No stay, fine, Mullahs, no stay. We went before the Election Commission and said, you cannot decide this matter. The matter is pending in Supreme Court. He said, no, but Supreme Court has said no stay. And you will find that tomorrow, Mullahs, when your lordships sit at 3:30. But be that as it may, that's the last question that your lordships, your ladyship will have to look at. So these broadly, Mullahs, are the issues that you might be asked upon to decide, Mullahs, that you might wish to decide. Now, Mullahs, let's go to the list of dates, because unless you have the facts, Mullahs, it will be. Mullahs, this is now PDF page 108 of the written submissions. It is marked as capital A, and I have learnt how to use the iPad.
Mr. Sybil, just wondering if you could just look at the issues that were framed.
Ladyship, I can't hear you.
Look at the issues that were framed once so that we know the perspective in which you're arguing. The issues that were framed for reference to the Constitution.
I can read those.
Can we just to review?
Yeah, I think it's a good idea.
Call before we
Reference
proceed
order.
further.
Yes, reference order. Your lordships will have that. Order compilation, Mullahs. PDF page 28.
Order compilation.
Orders compilation, PDF page 28. And the questions start at page 30.
Is the order dated?
It is on order dated, Mullahs, 23rd of August, 2022.
Page 28.
Page 28, Mullahs, and the relevant part, the question starts at page 30 at the bottom.
Order compilation, right?
28.
PDF page 30, Mullahs.
28.
Your ladyship has it? Justice Shah, Mullahs?
Yes.
May I, Mullahs? A, whether notice for removal of a speaker restricts him from continuing with disqualification proceedings under the 10th schedule of the Constitution as held by this court in Nabia. Mullahs, I've already argued that. So lordships, Mullahs, have deferred your lordship's judgment on that. So we'll skip that for the moment. B, whether a petition under Article 226 or 32 lies inviting a decision on a disqualification petition by the High Court or the Supreme Court, as the case may be. That's the question that I have already formulated in different, the language is somewhat different, but the intent is the same. Then C, can a court hold that a member is deemed to be disqualified by virtue of his or her actions absent a decision to the speaker? Actually, B and C are together, Mullahs. They are interlinked.
Per se cases.
Yes. The language is somewhat, Mullahs. D, Mullahs, what is the status of proceedings in the House during the pendency of disqualification petitions against the members? Mullahs, it really doesn't clarify what it means. What is the status of proceedings? What it means is that can members against whom there is a disqualification petition pending have a role to play in the House while it is pending? Otherwise, you can topple any government you want. Then E, Mullahs, if the decision of a speaker that a member has incurred disqualification under the 10th schedule relates back to the date of the action complained of, then what is the status of proceedings that took place during the pendency of a disqualification petition? Now, Mullahs, this question only arises if you allow proceedings to go on. If you don't decide on the disqualification before, then this question arises, because if at a later point in time, you consider them to be disqualified relating back to the date when their act led to a voluntary giving up membership of the party or violation of the whip, Then, Malas, what happens to the intervening proceedings? A government has been formed, actions have been taken, policy decisions have been made. Would it not be better for the purposes of, I personally believe, democratic traditions, that you should await your hands till the disqualification is decided first, because this problem will not arise then. Then, Malads, F, I think, is very, very important. What is the impact of the removal of paragraph 3 in the 10th schedule? According to me, that's central to the entire issue. Because now you don't have a split. The issue of a split doesn't arise. Which is why, if you want to go to the election commission, there has to be a split in the party, not a split in the legislature. That is not on record. No such split. So this is central, and we'll interpret paragraph 4 also in that context. Then G, what is the scope of the power of the Speaker to determine the whip and the leader of the House legislative power? What is the interplay of the same with respect to the provisions of the 10th schedule? Well, it's actually, again, convoluted in its expression. In simple terms, it means that how is a whip appointed and how is a leader in the House appointed? Is there a role of a political party, or is it something that the legislative party decides? Can majority of the legislative party members decide, I'll change the whip tomorrow? Can't be. So what has happened in this case, and I'll come to the facts, Mullahs, that sitting outside the House, X number of people said, you are no longer the whip. And those are members of the legislature only. Mullahs, I can give your lordship's documents to the effect. What happens is, when a leader of the House is appointed, the letter that is given to the Speaker is that the party hereby decides that this person will lead the House for the party. It's not the members of the legislature don't decide these issues. Similarly, whip. Because the whip is the bridge between the government or the opposition, whichever party it is, and the House, members of the legislature. That's why your lordships will see that nowhere in the Constitution does the word political party is referred to, except in the 10th schedule. Because in the Constitution, you're dealing with institutions. You're dealing with an institutional framework within which all political parties function. In the 10th schedule, you're dealing with framework within which a legislative party functions in the context of the political party, resulting in disqualification. Then, Malads, H. Are intra-party decisions amenable to judicial review? I don't think that question arises. There's no intra-party decision in the legislature. So your ladyship is right that we need to look at some of these questions. Then I, what is the extent of discretion and power of the governor to invite a person to form the government, and whether the same is amenable to judicial review? Well, it's governor's actions are always amenable to judicial review. That's not an issue at all. Question is, what should a governor do in the context of disqualification petitions pending and which are yet to be adjudicated upon? As a governor, Maharaj, who he is a constitutional authority, he needs to protect the constitution and the laws. In this very state, a governor, Maharaj, in the early hours of the morning, gave an oath, to the oath of office, Malas, made somebody a chief minister, and by the early morning, Malas, on daylight, he had to resign. Governors, and I say this with respect to all the institution of the governor, that governors have, in my respectful submission, acted far beyond their constitutional responsibilities, as we have seen, as I have seen in the recent past. That may not be a proposition that the other side will accept, but I'm giving only my view of the matter. It is unfortunate that governments are actively involved in the politics of the country. Then, Malas, the last one. What is the scope and the powers of the Election Commission of India with respect to determination of a split within a party? That's where, Malas, the question of para 15 of the symbols order comes in. Let's kindly now come to the written submissions of the petitioner. And the list of dates is at page 108. PDF 108.
Submission.
That is A, right? A, petitioner written submission.
10, yes, A. PDF 108.
Written submissions of the petitioner.
Written submissions, no?
Yes.
You are referring to written?
Yes.
Not additional written submissions. Not additional written submissions.
A, Manas, A.
A.
Page 108, PDF.
Mr. Sibal, what we could also do is that, of course, we've seen the broad points of reference, but ultimately we'll need to narrow down the reference to the issues which you want to focus on.
Yes.
And maybe if you could, during the course of the afternoon, share that with the other side. We can have their feedback so that we narrow it down to certain specific issues. Because many of the issues which have been framed in the reference order may not strictly arise.
Yeah, it's not necessary. I said that
let's
already.
sort of structure that so that it'll lend some clarity to.
Well, let us do that in the evening. Well, that would be much easier for us. Because
Difficulty.
if your lordships will allow us, because I'll consult my colleagues.
Yes, absolutely.
We'll give some
We'll just
agreed
sit down,
issues, Malad,
in the evening and give us some agreed issues which will arise.
because afternoon may not be the most appropriate.
Evening would be fine.
Yes, we will.
And also then we can have some idea about, the time schedule, how long would you take? So that then we can restrict them as well and to certain time.
Malad, this side, Malad, will take 3 days, Malad.
Mr. Sibal, how long would you take? About 3 hours or so today?
No, Malad, I'll take much more tomorrow too.
Mr. Sibal, we'll have to have structured arguments.
All right, it'll be structured, Malad. I'm not going to repeat myself at all. Your lordship knows I myself, Malad, reduced,
After Mr. Sibal, after you conclude, Dr. Singhvi will.
Dr. Singhvi and then Mr. Kamath, my colleague, Mr.
So
Kamath.
why don't, maybe we could do this. We have about an hour and 15 minutes before lunch. and you get 2 hours after lunch today. That's about 3 hours and 15 minutes. So maybe if you could conclude today by 4 o'clock, then we can give Dr. Singhvi until lunch tomorrow.
Yes.
And then a little supplement to half an hour after lunch for Mr. Kamath.
Yes.
And then they can start tomorrow afternoon. We are breaking at 3:30 tomorrow. So they get about an hour and a half in the afternoon. And maybe on Thursday, they can conclude by maybe lunch. And then we give you...
We'll try that, Manoj. We'll try that. No issue, Manoj. We'll certainly try and speed it up. I mean, I just think, Manoj, your lordships may have questions yourselves.
No, of course. If we find that, of course, there's a little change in the time schedule, we can certainly do
Then, Manoj, your lordships will also have to decide on the Nabam reference at some stage, what your lordship wants to do, because that sort of opens up another.
So we'll look at the list of dates?
Yes, Manoj. So on 1966, Shiv Sena, founded by Bala Saheb Thackeray, to espouse the ideology and legacy of whatever, and has been recognized as a state political party by the Election Commission. Bala Saheb Thackeray was the president, Shiv Sena Pramukh of the Shiv Sena from its very inception and continued in the role till his demise on 17th November 2012. After the demise of Bala Saheb Thackeray, Uddhav Thackeray was unanimously elected to be president, Shiv Sena Paksh Pramukh of the Shiv Sena political party, and has continued to hold the position. At present, Shri Uddhav Thackeray unequivocally continues to be the Paksh Pramukh of the Shiv Sena, president of Shiv Sena, which is the highest position as provided in the constitution of Shiv Sena. Copy of the constitution is annexed. 85, in view of the repeated defections of elected MLAs, MPs, and with a view to curb horse trading of an elected representative, the constitution was amended to include the 10th schedule by virtue of the 52nd Amendment to the Constitution with the following statements and objects. The evil of political defections has been a matter of national concern. If it is not combated, it is likely to undermine the very foundation of our democracy and the principles which sustain it. With this object, an assurance was given in the address by the President to Parliament that the government intended to introduce in the current session of Parliament an anti-defection bill. This bill is meant for outlawing defection and fulfilling the above assurance. So nothing in the 10th schedule should be interpreted to give credence to a defection. Nothing in the 10th schedule should be interpreted to somehow legalize a defection. Give credibility to that process, because the whole object of the act is to ensure that there are no unprincipled defections. Well, there is an elected government. The attempt of the court and of the institution of the governor should be to allow the elected government to function till such time as a person is either disqualified or not disqualified. Right? And if there is a disqualification petition, that should be allowed to be decided. Because if you don't allow that to happen and you pass an order like you did on the 27th of June, unfortunately, it's the judicial order that led to this. It is that judicial order that led to this. Had that not been passed, we wouldn't be here. And if the speaker had been allowed to decide, and they would have gone up in appeal if there was a decision against them, or somebody else would have gone up in appeal. Yes. So, Malad, 7th of April, the 10th schedule was amended by the 92nd Amendment, and paragraph 3 thereof, which permitted 1/3 members of the legislative party to split, was omitted. Split is no longer available as a defense against disqualification under the 10th schedule. Malad, please mark that. The defenses available were only two. That I have 1/3 of the legislative party has split, pursuant to a split in the political party. It is not a split of the legislative party. Paragraph 3, and I'll read that, Your Lordships, it is a split in the political party, resulting in 1/3 of the members in the legislative party, which gives them a defense to say that they cannot be disqualified. Similarly with paragraph 4, it's a defense. If I am 2/3 and there's a merger of the party, it's a defense saying, now I am entitled to be that party. That is part of the new party. Either the original, a new original party or part of the merged party. That's a defense. That's why I indicated to your lordships, now there's no question of majority, minority, 1/3, 2/3, no, not relevant, if there's a split. Because what? The purpose of the defection law is to ensure that there is no unprincipled defection. Then, my lords, 23rd of January, organizational elections of the Shiv Sena political party for term 2018 to 23 were held, wherein Uddhav Thackeray was elected as president. The results were duly communicated in the prescribed format to the Election Commission on 27th of February 2018. Well, the Election Commission, and that, your lordships, is not relevant here. Election Commission in its order says, I don't have your constitution. Therefore, I will not consider that you are about the organizational wing structure. I will not consider it at all. So I go only by what is the legislative majority, and the legislative majority is 38 people from Eknath Shinde group, therefore they get the symbol. Anyway, that's another matter. Then, my lords, October 2019, elections in the 14th Legislative Assembly of Maharashtra were held. The seat distribution in the said election inter se of political parties is following. Your lordship knows this. You have seen it before. Then, my lords, November 2019, a post-poll alliance was formed between the Shiv Sena, the NCP, as well as the INC called Maha Vikas Agadi to form a stable government in the state of Maharashtra, with the president of Shiv Sena, Uddhav Thackeray, being sworn in as the chief minister. 23/11/2019, prior to the swearing in of Thackeray, the governor hastily sworn in Devendra Fadnavis early in the morning as the chief minister of Maharashtra. This honorable court in Shiv Sena versus Union of India directed an immediate floor test, and Devendra Fadnavis resigned before facing the floor of the House. This only indicates how governors, mullahs, have been conducting themselves. How can a governor have sworn in somebody as a chief minister without knowing that he has majority in early hours of the morning?
This order is on 23rd November,
Yes,
Supreme Court's order.
yes. Oh, the order, I just... 2019, 10 SCC 809.
Tell me later.
Yes. Then it's mentioned. Anyway, April, May 2020, governor has been at loggerheads with the 2511. Oh, 2511, Sunil Prabhu. Now, this is important. 2511, Sunil Prabhu is appointed as chief whip of the Shiv Sena Legislative Party with the blessings of Uddhav Thackeray, president of the Shiv Sena political party, and the same was duly notified to the Speaker of the Maharashtra Legislative Assembly. Well, that, your lordships may actually, if your lordships don't mind, look at that document. Or do you want to read the dates and then later?
Please read the entire dates.
All right, all right.
Break of
Then April, May 2020, the Honorable Governor has been at loggerheads with the MVA government and has almost created a political crisis. Governor was sitting on Shri Uddhav Thackeray's recommendation for nomination to the Maharashtra Legislative Assembly, despite a period of 6 months as an unelected member was about to expire on 27/5/2020. Further, the governor had blocked holding of the speaker's election. No speaker's election took place. Well, he was not a member of, there was a seat, for in the Legislative Council, which had to be, he had to be elected from that seat. He wouldn't hold the election for almost 6 months. This tells you, how constitutional authorities are acting. First you swear in somebody, he resigns the next morning, or then you have this problem. The BJP has been attempting to create divisions within the Shiv Sena, 20th June 2020, in the recently conducted MLC election, wherein despite having the requisite number of MLAs on its side, the MVA alliance led by Shiv Sena lost a seat to the BJP. This was because of cross-voting within the MVA and particularly within the Shiv Sena at the behest of the BJP. I'm not going to rely on these facts, because this is disputed. So that these facts I'm not going to rely on. It was widely reported in the media that Eknath Shinde, who was then the Cabinet Minister of Urban Development and Public Works, has, along with certain others delinquent MLAs of the Shiv Sena, gone into hiding in the BJP-ruled neighboring state of Gujarat. Then 21-6, these are the undisputed facts that now start. To contain and allay the apprehensions that were arising in the party post the MLC elections, an urgent meeting of the Shiv Sena Legislative Party was called on the 21st of June. Eknath Shinde, along with certain other delinquent MLAs, did not attend the above-mentioned meeting, dated 21st of June. The party resolved in the said meeting to remove Eknath Shinde from the position of the leader of the Shiv Sena Legislative Party and appoint Ajay Chaudhary instead. Now, this is interesting because this is a matter which your lordships has to constitutionally consider. So a faction, which is a legislative party, decides that I will change the whip. Constitutionally impermissible. Then, the decision, Eknath Shinde, along with certain other delinquent MLAs, did not attend the meeting. Party resolved in the said meeting to remove Eknath Shinde from the position of leader of Shiv Sena and appoint Shri Ajay Chaudhary instead. The decision to remove Eknath Shinde was communicated by Uddhav Thackeray to the Honorable Deputy Speaker. After due verification, the Deputy Speaker accepted the change of leadership of Shiv Sena in the House. The reason why this happened was, because, as your Lordship knows, he had to be a member of the Legislative Council because there was no seat in the Assembly. So the then Chief Minister became a member of the Legislative Council. Therefore, in the meantime, somebody had to be appointed, as the leader of the House, because they were the treasury benches. So Eknath Shinde was the leader of the House. And he was removed from his position of leadership by a decision of the party. And the Deputy Speaker was told about it and he accepted it. In the larger interest of the party, it was thought fit to call for another legislative party meeting to give one more opportunity to the MLAs who were absent in the meeting on 21st June to show their loyalty and support to the original political party. Hence, another meeting of the SSLP was called. Individual notices were issued to all the MLAs of the Shiv Sena, and it was made adequately clear that, quote, failure to participate in the meeting without providing valid and adequate reasons in writing, communicated in advance to the underside, will result in consequential action against you under the relevant provisions of the Constitution. So they were told. On 22nd of June, despite the importance of the meeting called on 22nd June, aimed at consolidating the SSLP's strength to contain any possible horse trading, several dissident MLAs did not attend the meeting. Instead, the delinquent MLAs sitting in BJP-ruled states sent communications rejecting the holding of the meeting as illegal, which itself shows that those MLAs had been working contrary to the diktats of the original political party. 22nd of June, Sunil Prabhu, in the capacity of Chief Whip, responded to the communication dated 22nd of June of the delinquent MLAs rejecting the reasons given for their absence from the SSLP meeting as an afterthought, frivolous, backdated, and proof of them acting contrary to the interests of the original political party. That's the notice that your lordships read, 21st of June, dated 21st of June, received on 22nd of June at 11:30 a.m., but dated 21st June. Eknath Shinde wrote to the Deputy Speaker communicating his appointment as leader. So now, the legislative party or a majority of the legislative party can decide who they're going to be the leader of the party in the House, of the party, sitting in Assam. On 22nd of June, simultaneously, a purported notice for removal of Deputy Speaker Narhari Zirwal under Rule 11 of the Maharashtra Assembly Rules, read with 179, was received at the Legislature Secretariat, expressing no confidence in the Deputy Speaker. Notice was hand-delivered by an unknown courier and not by any MLA. It is also relevant to note that none of the purported signatories of the notice had personally delivered any such notice, nor it was sent through the registered email address of any of them. The Shiv Sena Legislative Party in its meeting took note of Shri Eknath Shinde and rebel MLAs, and the fact that they had indulged in anti-party activities and were trying to destabilize the MBA government. In view of this, it was resolved that the Shiv Sena Legislative Party meeting at the then CM's residence, that necessary legal action shall be taken under the 10th schedule against the errant MLAs. Now, who is CM? CM Malaj is a member of the Legislative Council. He is also the Param Pramukh, Paksh Pramukh. So he is the political leader. He is the one who decides. June 23rd, Sir Sunil Prabhu filed disqualification petitions under para 21A, seeking disqualification of Eknath Shinde and 15 other delinquent MLAs of Shiv Sena. 24th of June, it was widely published in the news reports that the rebel MLAs led by Eknath Shinde were acting in collusion with BJP, and their entire logistical arrangement in Guwahati was made by the BJP leaders. 24th of June, Secretary of Maharashtra Legislative Assembly received an email from an advocate named Vishal Acharya attaching notice for removal of the Speaker dated 21st of June. On the same day, the Secretary of the Assembly communicated the decision of the Deputy Speaker to the email of Vishal Acharya, refusing to take on record the communication dated 22nd of June until the genuineness and veracity of any such communication and its signatories was ascertained. 25th of June, one of the dissident MLAs, Deepak Kesarkar, in a live interview declared that the dissident MLAs had formed a new group and named it Shiv Sena Balasaheb, and had also announced that they will have a separate leader whip, office, and everything else, just like a party has. 25th of June, Honorable Speaker, after due verification, was pleased to issue notices to the delinquent MLAs under Rule 6 of the Maharashtra Legislative Assembly Disqualification on Ground of Defection Rules 86, read with the 10th schedule of the Constitution, asking the delinquent MLAs to file their replies by 5:30 on the 27th of June 2022. On 25th of June, the National Executive Meeting of the Shiv Sena was held. The said meeting was attended by over 163 representatives of the National Executive, and the leadership of Uddhav Thackeray as the President of Shiv Sena was unanimously and equivocally accepted by the National Executive. 25th of June, Sunil Prabhu filed an additional affidavit in the disqualification proceedings inter alia, containing the media reports that showed the hobnobbing of the delinquent MLAs with BJP leaders. 25th of June, Sunil Prabhu filed disqualification petitions against 2 independent MLAs and 1 MLA belonging to the Prahar Jan Shakti Party. The petition against the independent MLAs were filed on the ground that they gave up their independent status by taking part in the resolution dated 21st of June, passed by the rebel MLAs, and signing the said resolution on the letterhead of SSLP. Also, the ground taken against BJP MLA was that the said MLA voluntarily gave up membership of the original political party by taking part in the said resolution dated 21st June and by signing the same on the SSLP letterhead. 27 June, issuance of the notice of 25th June by the Honorable Deputy Speaker came to be challenged by the 16 MLAs, including Shri Eknath Shinde, who filed a writ petition under 32. The said court, the Honorable Court, by the interim order dated so-and-so, in writ petition so-and-so, was pleased to, in the interim, direct this. Thus, meanwhile, as an interim measure, the time granted by the Deputy Speaker of the Assembly to the petitioners or other similarly placed members of the legislative party to submit their written submissions up to today, today 5:30 p.m. is extended till 12/7. Well, just kindly note the language here, as an interim measure. They have not filed a reply till date. We are now in February 2023. They have not filed a reply. Now, Malaj, prior to the passing of this judicial order, Malaj, all that happened was happening outside of Bombay, outside of Maharashtra, in a state in the northeast. And by whom? By these members of the Legislative Assembly, that's all. There was no party in sight. There was no meeting of any party. Nobody called for a meeting of the party. And these are undisputed facts, Malaj. These are not disputed facts. Can the 10th schedule countenance a situation where, because of whatever reasons, we don't want to go into it, a majority or even a minority of MLAs are just, let's forget the majority. Supposing a minority, you don't sometimes need the majority to topple a government. You'd only need a minority. Supposing it's a minority, and the minority outside the state of Maharashtra says, I have formed. I am the political party. And then a judicial order is passed on a disqualification petition. Then no. If a petition is filed, you can file your reply after 10, 15 days. In the meantime, the minority gets in touch with the other party, topples the government, a new chief minister is appointed. Can you ever imagine that the 10th schedule would allow that? Can it ever be countenanced? This is harakiri. This is legislative harakiri. Political harakiri. And you can't interpret the 10th schedule, in this particular fashion to allow an elected government to fall. That's why I said it is judicial orders of this court that resulted in this. Then, 27th of June. As several other members of the SSLP had also openly indulged in anti-party activity. Now, can anybody say, that this is not anti-party or this is not giving up membership of the party? One of you sitting there say that we are forming a new party called Shiv Sena Bala Sahab. And you are sitting in a state ruled by the opposite, ruled by a party, which was in the opposition. First you go to Gujarat, then you go to Assam. There is no dispute on that. These actions per se amount to giving up membership of the party, apart from the fact that you don't attend the meeting on 21st, 22nd of June. So what is the speaker going to decide? What can he decide? Given these facts. Then 28th of June, late in the evening, the leader of opposition in the state of Maharashtra, Devendra Fadnavis, went to meet the governor and requested him to hold a floor test after the stay. That's where the role of the governor comes in. On 28th of June, immediately after meeting Devendra Fadnavis and with utmost haste, the governor sent a communication dated 28th of June, though received in the early hours of 29th of June, to the then Chief Minister, directing him to face a floor test in the House on the very next day, 30th of June. It is relevant to note that the Honorable Governor did not even attempt to ascertain from the Chief Minister whether he enjoyed the majority of the House. On 28th of June, the Governor, by way of a separate communication dated 28th of June, which was received in the early hours, directed the latter to forthwith on 30th June to convene the Assembly and hold a floor test. 29th of June, Sunil Prabhu filed a writ petition before this Honorable Court seeking a stay. So, we said, please stay the matter. Please don't allow this to happen. Of the directions of the floor test in view of the fact that the disqualification petition of 42 MLAs under the 10th schedule are pending. By order dated 29th of June, in writ petition so-and-so, this court was pleased to direct as follows. Having given a thoughtful consideration to the rival submissions, we do not find any ground to stay convening of the special session of the Maharashtra Assembly. How? Vidhan Sabha. On 30th June, tomorrow at 11 a.m. and with the only agenda of a trust vote. So therefore, you give legitimacy to those against whom disqualification petitions are pending, and such legitimacy that they are able to topple the government by colluding with another party, which is in opposition in that very state. That's the effect of the judicial order. So first, stay the proceeding before the Deputy Speaker, then allow this collusion and get an elected government toppled. What used to be the misuse of 357 has now been substituted by the misuse of the 10th schedule. 356 was now misuse of the 10th schedule. And this The proceedings of the trust vote to be convened on 30th of June shall be subject to the final outcome of the instant petition. That's another interesting thing with us. Proceedings of the trust vote shall be subject to the final outcome of the instant petition as well as the writ petitions referred to above. So therefore, my lords, every action of the governor resulting in a new government having been formed is subject to your lordship's decision in these petitions. So you cannot give it the color and clothe it with legality because the judicial order itself says that it's subject to. So you cannot say now the trust vote has happened, now a chief minister has been installed, now a government is in place, now you can't do a thing about it. The special session of Maharashtra Vidhan Sabha shall be conducted in accordance with the directions that contained in the communication dated through 28th of June of the Governor of Maharashtra. Then 29 June, Chief Minister Uddhav Thackeray resigned because he knows the writing was on the wall, having given legitimacy to those who then 30th of June at around 3 p.m., Eknath Shinde and Devendra Fadnavis met the governor and staked claim to form the government. This is also anti-party activity. No evidence is required on this. Then 30th of June, the governor, without taking into account the fact that the membership of Eknath Shinde itself was in dispute, here again the question of the governor comes in dispute. In the imminent disqualification petition pending against him, swore Shri Eknath Shinde in as the Chief Minister and Devendra Fadnavis as the Deputy Chief Minister of Maharashtra. The Honorable Governor thereafter directed Eknath Shinde to prove his majority on the floor of the House. We knew that everybody knows that he would have the majority thus. You can fool the constitution, but not the arithmetic. Then the governor, without taking into account the fact that the members, and I've read that. Then 30th of June, due to their anti-party activities which unquestionably amounted to relinquishing membership of the Shiv Sena political party, Shri Shinde, Tanaji Sawant, Uday Samant, and Gulab Rao Patil were removed from their positions in the organizational setup of the party by the undisputed president of the Shiv Sena, Shri Uddhav. Well, let's just note here, no meeting of any political party took place at the instance of Eknath Shinde. And you will see that tomorrow in the petition before the Election Commission. That alleged meeting, which I'll show is bogus, happened to have taken place on 18th July, after all this was over. And the petition for getting the symbol was filed on the 19th July, on the very next day. Then, Malats, one second. Yeah, I'll take it. Then, Malats, 1st of July, 2022, Shiv Sena Secretary sent a letter to the Election Commission intimating the authority regarding the removal of Eknath Shinde from the positions of Shiv Sena and change in the organizational setup of Shiv Sena thereto. Also, by the separate letter, the Shiv Sena Secretary intimated the ECI regarding the removal of Tanaji Sawant and Uday Samant from the organizational position of Shiv Sena. Similarly, the Shiv Sena Secretary sent another letter to the Election Commission of India intimating the authority regarding the removal of Gulab Rao Patil from the organizational position of Shiv Sena. On 1st of July, an application for directions, IA such and such, was filed by Sunil Prabhu in the present writ petition seeking an interim order suspending the delinquent MLAs against whom disqualification petitions have been filed till the final adjudication of the 10 scheduled proceedings. The said application was mentioned before this court for urgent interim listing, wherein this honorable court directed to list the application along with the writ petition on 11th of July. Then 2nd of July, the Principal Secretary, Maharashtra Legislative Assembly, circulated working order for conducting election to the office of Speaker on 3rd of July, The said agenda showed that the name of Rahul Narvekar was proposed by the BJP MLA and the name of Ranjan Prabhar Salvi was proposed by Shiv Sena. So this Rahul Narvekar was proposed by a BJP MLA because he happened to be a member of the BJP. Then 2nd of July, Sunil Prabhu, acting as chief whip, issued a whip. Now, till that day, Sunil Prabhu is still the whip. Acting as chief whip of SSLP, issued whip to the members of SSLP regarding the election of the speaker, scheduled on 3rd of July. All the party members were asked to remain present in the assembly and vote for the Shiv Sena candidate, Rajan Salvi. Sunil Prabhu issued a further whip to the members of SSLP regarding confidence motion, scheduled on 4th of July. All the party members were asked to remain present in the assembly until the end of the session and vote against the confidence motion. Well, as your lordships must just keep one thing in mind. It's not their case that they merged with any party. It's their case that they belong to the Shiv Sena. So if they belong to the Shiv Sena, then how can they disobey the whip? And vote for a BJP candidate against the Shiv Sena member. There is no evidence required here, Maharaj. Then on 3rd of July, Ajay Chaudhary, acting as the leader of the SSLP, submitted a letter to the Deputy Speaker requesting him to conduct the election of the Speaker of the Legislative Assembly by division of votes. Ajay Chaudhary on the 3rd of July submitted a letter to the Deputy Speaker requesting that the votes cast by the members of the Legislative Assembly who have incurred disqualification should not be considered during the election of the Speaker. 3rd of July, the election for the office of the Speaker of Maharashtra Legislative Assembly was held. Rahul Narvekar, the candidate for the Bharatiya Janata Party, was unconstitutionally elected as the Speaker of the Maharashtra Legislative Assembly after getting a total of 164 votes. During the elections, it was recorded by the Deputy Speaker that 39 delinquent MLAs of Shiv Sena Legislative Party, led by Eknath Shinde, had voted against the party whip. Now, at this point in time, there is no other whip. Now you will see on the evening of the 3rd, after
how many votes did the rival candidate poll that day?
Sorry?
July. How many votes did the rival candidate poll on the 3rd of July? Speaker.
That's all. We are not mullahs on majority minority. Yes, that's correct. I'm glad that my learned friend pointed it out, mullahs. Correct.
But therefore, if these 39 are excluded from 164, they still have 125.
I am not mullahs on that. I'm only saying that they voted against the whip, therefore they are deemed to be disqualified. That's all I'm saying, mullahs. I'm not saying, mullahs, whether he would have. Supposing, mullahs, all of them are disqualified, because on that particular day they voted against the whip.
These 39.
All 39.
No, but therefore, if you exclude these 39
yes,
from the 164,
yes,
they're still down to, they still get 125, right?
That's right. Fact.
Your lordship is right, mullahs. At the moment, mullahs, I am not challenging. At the moment, mullahs.
Because this comes soon on the heels of the trust vote, which takes place on the 30th.
Yes.
So this is now an indicator within 3 days.
Trust vote happened on the 4th.
Because Mr. Sibal, you don't
happen on the 30th, mullahs.
Right. You don't ultimately you don't face the trust vote.
Yeah, I don't, mullahs. So therefore, it is held on the 4th, and we challenge the trust vote also. We've challenged all decisions, the election of the Speaker, trust vote, whatever. All that is challenged. Mullahs, the question is, at the moment, mullahs, we are dealing very, very limited issue. One, should the courts have given time?
That's a separate issue because it's an order which is an interim order.
Yeah, it's an interim order. What was the result of that, mullahs? That these people were able to topple the government without the disqualification petitions having been decided. There was an elected government, mullahs, which was in power. The 10th schedule was used for the purposes of toppling an elected government. And supposing tomorrow, mullahs, your lordship holds by these actions, which are uncontroverted, that they disqualify themselves both on both counts, 2-1A and 2-1B, what will be the result? And if your lordship holds otherwise, let's assume against me, then this will be, you have given them a model to topple every elected government.
But Mr. Sibal, are we not still down to, if you are really looking at the numbers here, are we not down to the situation where the speaker's election at least indicates that because 38 was sought to be disqualified, there were disqualification petitions against the 38. Now, if you exclude the 38 for a moment from the 164 who voted in favor of the resolution for the speaker, you still have a situation where that's in very close proximity to the date on which the trust vote was to be held, on the 30th.
Yes.
Now, you resign, right, on the 30th.
Yes.
And therefore, is this not really clearly an indicator that even excluding these 39...
That's all right. The speaker could have been Millet. Yes, I'm not disputing that, Millet. I'm not sure what the arithmetic is. Half 145 is the halfway mark, Millet.
What my Lord the Chief Justice
You
asked.
deduct 34, you are below, Millet. I'm sorry. In fact, the arithmetic is the other way.
No, my Lord, 288 was the total.
Yeah,
What's the number?
Just give it.
288
We'll just give you the
strength of the assembly. The
Paul.
actual,
Just 1 second.
yes,
Total strength of the assembly.
288.
That was there from Mr. Sibal's chart, which we
Right.
saw.
Actual votes received by Mr. Narvekar were 164, which is over the 50% mark of 144.
Just 1 second. Just one second. Total
So
strength of
the
the
half
assembly.
mark would be 145.
Just a
1 second.
yes.
164.
So if 144 is the halfway mark, 145, 164 votes were received by Mr. Narvekar if the strength was taken to be 288. If 39 MLAs are excluded from the strength of the Legislative Assembly, the effective strength comes down to 249.
249.
And out of those,
Just 1 second.
249, half of it is
249 and then.
and the effective votes received by Mr. Narvekar were 125, which is over 50% of the votes required. So under any circumstance, even if 39 MLAs are removed.
Plus, there were only 16 disqualifications.
Yes. Plus on that date, there were only 16 disqualifications, but I'm going a step further. Even if there were 39 disqualifications, even then Mr. Narvekar was through.
what is the halfway mark of 249?
120.
124 minutes.
120.
125.
And he had 125.
Exactly the same.
Yes. And at 12:01, they move a resolution expressing disqualification, expressing no confidence. It is defeated
And 175. 9C.
and later again and defeated.
Oh. Maharaj, there were 3 independent disqualifications also, apart from this. 1 second, hold on.
Now, maybe the issue was argued.
1 second,
It
1
was
second.
pointed out that in under any circumstance.
Sir, 1 second, 1 second. There were 3 disqualification, independent also were subject to disqualification. So it makes it below 125. Total is 41.
But then the strength of the house also comes down.
That's all right, but you don't get the majority then. But Maharaj, as I said, we are getting involved in issues that are not an issue before the court.
49, you will have to exclude the independents also. And therefore, the halfway mark will accordingly be that. Is that what you say?
So the total, let's go over it again. Total strength of the assembly is 288.
Yes,
The halfway mark is 145.
that's right.
Excluding the 39 Shiv Sena MLAs
Plus,
and plus 3 independent MLAs. Just 1 second.
it'll be 246, Maharaj.
Just 1 second.
And they would be having 122.
So the strength of the house was 287.
But Maharaj, the 10th schedule doesn't talk of any of this. You can
So
do
we
the
then come
arithmetic.
to, we would be down to,
42. 42.
that is 42. So the effective house, strength of the house comes to 288 minus 288 minus 42,
Yes,
which
yes,
is
yes.
248 and 246.
46.
46.
123 is the halfway mark. Whether they won or lost is not the issue. They'll still be disqualified.
No, that's all right. Your constitutional argument.
124 is the halfway mark, Malas.
123, 246.
124.
123.
123.
123.
246 minus,
Malas, it has to be, one more has to be given for halfway mark.
So halfway mark is 123 and Narvekar gets 125.
Three more Malas
No,
are
the
disqualified.
of three. You have included those three.
164 minus 42 Malas.
Yes.
Inclusive of
So 122.
So if we exclude those
Yes,
three, then he
yes.
gets 122.
122. So it's below the halfway mark. But be that, Malas, the 10th schedule is not concerned with this, Malas. We're not concerned with that, according to me.
How can
1 second, because we have said so.
how can three independent MLAs?
How can we? That is to be decided by the speaker.
You can say what you want, but if there are three independent MLAs, they can't be disqualified by you.
even independent.
Who says that?
Procedure. They can't be,
Malas, my learned friend should,
they are today claiming that they
One second,
their disqualification.
Mr. Call, you have to read the 10th schedule.
Independent MLAs are
Please
concerned.
read the 10th schedule before you make that submission. But unnecessarily, there's no point in making a submission which is contrary to the 10th schedule.
No, but the most crucial fact is that the disqualification petitions were only against 16 and not
Doesn't
39
matter.
MLAs.
Malas,
The
One
disqualification
second.
MLAs were only 16, not 39.
1 second. In fact, on the third, all 39 are under disqualification because they voted against the whip.
That's after the vote. That's after the speaker.
No.
We are proceeding.
Not, it's before the
Assuming
speaker.
that It is actually the entirety of the 38 comes in. Where is the position?
Malas, I don't think this arithmetic exercise of any relevance for the purposes of the 10th schedule.
Point, you get
Yes.
the point that it's 10th schedule issue.
Yes, correct. It's just a matter of arithmetic. Malas, majorities are made up like this only, Malas. I was on 40.
yes.
So if you exclude the 29 plus
Please.
125.
No, that's.
No, minus those 39, 125.
Sorry, Malas, we
Otherwise,
are
he
not
got
on 39. We are on 40, 42.
Just give us the number that he has got now, Rekha.
Narvekar gets total 125 votes.
Is that right?
No, he gets 164.
164.
Actual
164.
votes are 164.
Yes.
Now we have to now consider. I mean, we just for the
Yes.
from 164 you suppose deduct 39. Which are the 39 persons against whom you say they are disqualified?
No, even the other three, we said the same, Malas.
But
We filed a petition to that
one
effect.
second.
Yes.
Therefore, if you exclude 39, the Shiv Sena MLAs and 3 independents, so you exclude from 164, 42,
Yes,
you're down to 122.
that's correct.
But they only had 107. They got 107 votes for their speaker candidate.
I think one MLA had died as well. When was that? So the actual strength was 287, right?
Majority? If they had obeyed the whip, we'd be in majority. He would not have got elected. 107 plus 39 or whatever. So, Mother, this is we are going into areas which have really not our concern at the moment. My concern is what happened and how the 10th schedule, in fact, which was meant to deal with.
Mr. Sibal, therefore, it also appears that apart from the 39
Yes.
who, according to you, were disqualified, the 3 independents, of course, that you say they shouldn't have, they are also liable to be disqualified. There are other members of your legislative party who also voted in favor of Mr. Narvekar, that means.
Yes. No. Some remained absent, Mother. They didn't vote. They didn't vote for that.
No, Narvekar polled 122.
Yes.
After excluding 39 SSMLAs
Yeah.
and 3 independents,
42.
Narvekar still polls 122.
Correct. So some must have been absent, Mother. Some would have been absent. There were 13 independents, Mother. There are 13 independents, various parties, SP, PJP, CPM, DVA, MNS, Swabhiman Party, Rashtriya Samaj Paksha, KSP, all kinds of parties are there. Not my proposition has nothing to do with the speaker.
We get that point. You're very
What you are really saying is that, look, irrespective of the numbers game, so to speak, according to you, first, the speaker could not have been thwarted from deciding the disqualification
Yes,
petition.
yes.
And second, a trust vote could not be held when the disqualification petition was still
Pending.
pending before the speaker. That really is too.
Those are the 2 points, Mother. And the governor should not have sworn him in. That's the action of the governor. He could not have sworn in a man, Mother, who is facing disqualification.
But Mr. Sibal, we also have to go into the wider issue as to whether can a trust vote in that sense, or should a trust vote be postponed?
Yeah.
Really because the disqualification petition is pending.
Pending.
No, Malaj. The question is whether time should have been given to them. It all comes down to 27th of June.
27th, yes, that's the first.
So, Malaj, the trust vote only happened after that, Malaj. Had that not happened, the trust vote would not have happened.
So therefore, in other words, what you are arguing is that the issue relating to
Raman.
10 schedule
Yes.
must be done later.
Yeah.
And what is to be decided is about the status of the party outside the legislative assembly,
Yes.
which is to be determined whether there is a split or a dissension in
Yes.
the party as a primary issue.
I'm deeply
And
obliged.
once that is decided,
Correct.
the question of 10 schedule triggers in thereafter is your argument.
No, trend schedule triggers immediately, Malaj.
10 schedule will trigger immediately.
Immediately, yes.
Because, but for 10 schedule, what is to be seen is the events with respect to the political party, not the legislative party.
No. Malaj, the 10th schedule cannot be subverted by members of the legislative party
Correct?
taking a decision that there is a split in the party
That is what I'm saying.
without there being a split in the party.
That's what I'm saying.
Yes.
That's your primary argument is that.
No, my Lord is saying what I'm saying. That's what my Lord is saying. the disqualification relates back to 21st of June. That's the day, Malad, that they have to show what is their defense under the 10th schedule. That's the day.
According to you, the speaker under 10th schedule only gives the declaration.
Yes, yes. That's correct.
So whatever has happened after 21st June, it
Yes.
is always subject to the disqualification from them.
That's
what you have submitted.
That's right. Because it relates back. That's your lordships. 5 judges have held that. Constitutional bench has held that.
So
That
today
is also one of the issue which is referred. What will the consequences in between?
That's correct. Your lordship is right. So that's why I've always said, Nabam Rebi and all that has to be decided by your lordships one day. All this has
So
to go ahead.
today, because the applications are pending,
Yes.
complaints are pending,
Yes,
the House is continuing.
yes.
It's not lapsed by flux of time.
No,
So the speaker is there for the
Yes.
House. Speaker decides today,
yes,
10 schedule
yes,
complaints.
yes.
It should relate back to
That's 21st of June.
2022.
That's correct. That's correct.
Then in simple cases, we should ask the speaker to decide.
But why ask the speaker to decide, Malas? For the simple reason, I tell your lordships why.
Your other argument that court should decide is a different matter.
Yes,
If the 10th schedule should operate, the complaints must be decided by the speaker prima facie to start with. So therefore, the argument is just this.
yes, yes, your lordship is right.
Decide now, he should decide now. Speaker is speaker, irrespective of whoever it is.
Correct,
If he decides, it will relate back.
correct,
Then
correct.
in other words, to say that we direct the speaker to take a decision.
The same thing should have happened to the deputy speaker on 27th of June.
Assuming, Mr. Sibyl, assuming you are right in everything that you have argued, that look, first, the 27th order should not have been passed, that the speaker should have been allowed to take a decision on the petitions for disqualification. What is the net consequence of your argument? I mean, what direction to take with the
The
court?
facts are undisputed. What is the speaker to decide in this? Malad, what is the speaker? I want to know what is the speaker to decide? What is the, Malad, what is the, Malad, they have not filed a reply till date.
No, but the question is who decides? I mean, the court can't take a decision.
Why not? Malad, the court decided. The court decided, Malad, in Rana.
Well, the power to decide a
They
disqualification.
did decide in Rana, Malad. 5 judges decided in Rana, saying that we will not send it back. The facts were undisputed. Malad, what is the, there can be no defense, Malad, because under the 10th schedule, there is no defense except a merger. What is the speaker to decide? And then your lordships will say, we can't issue a mandamus to the speaker to decide within 7 days. Then there'll be a constitutional issue referred to 5 judges then. Because you can't issue a mandamus to the speaker. Justice Nariman says within 3 months you should decide. No speaker accepts that judgment.
That
Well, where are we going?
got referred to constitutional bench.
Where are we going, Malad?
Chandra.
Malad,
But
the point
way
is,
you are raising the question, it'll require reconsideration of Kyoto.
I'm myself saying so, Malad. No, you please, whatever it is. I've said so twice already. It's only a merger, Malad. That's not their case.
But, Mr. Sibyl, just as you say that, look, on the 27th, the speaker could not have been stultified in taking a decision on the disqualification petitions. Once we adopt that principle, then we have to be consistent and apply that principle across the spectrum. Because there's a very valid point which you are making, which is that the speaker himself is a constituent, or the speaker themselves, I shouldn't say himself, the speaker themselves are constitutional authorities. Therefore, the Speaker has to take a decision under the 10th schedule.
Right.
If that is so, then we have to be extremely circumspect about, replacing the mechanism, the institutional mechanism which has been provided by the 10th schedule itself.
The problem in this case is, Malad, that this is because we perpetuated an illegality. Now the Speaker came into existence by perpetuating an illegality. And now you are giving the clause of authority to that Speaker who has actually come into place because by
So we can't reinstate the earlier Speaker because there we are trenching upon the
in
authority of the
Arabia, you
House.
did it. In Arabia, you did it. You in fact reinstated the entire government. I'm not saying you should do it, Malad, but if your lordship asks me that question, that's exactly what happened in Arabia.
Mr. Sipal, would the court not be getting into the thicket of the entire gamut by virtually clothing itself with the powers of the Speaker?
Malad, no, because the facts are undisputed, Malad. That's why I said these are undisputed documents. There is no political thicket here.
What you're saying is put the clock back in every which way. When you say a Speaker,
Because what?
Ultimately, Mr. Zibal, it will boil down to this. You have to say that, well, if you are logically consistent, that retrace your steps to the position in which we were before the 27th of June.
That's
And
what I
allow
said.
the
Malad.
political.
When I argued Nabam, that's what I said, and the court accepted it. That's exactly what I said. Because you cannot, this is all staring us in the face. As I said, forget a majority, minority. Mullahs, even 5 people can dislodge a government by saying that, all right, you have a trust vote now, new speaker is appointed, then every time the same thing will happen. Mullahs, your lordship looks at it the other point of view. If you do not, Mullahs, stop this menace now, it will be perpetuated. That's the other issue. Mullahs, I'm not saying your lordship, whatever your lordships will do, Mullahs, will be acceptable.
No, we are trying to explore that even assuming that your argument is correct, where does it lead the Constitutional Court to? I mean, therefore, that's something which we would like.
There are many things you can do. Mullahs, your lordships can say you decided within 7 days and you challenge the order if it's against you before us after 7 days.
Sorry, come again?
You decided within 7 days. They have not even filed a reply. Yes, let's assume, I'm giving your lordships your options, Mullah. Decided within 7 days, we are sitting here. If there's an order against you, come up and appeal and then we'll decide the matter.
that
In fact, the speaker issued notice against us, Mullah, on the 8th of July. He has not even issued notice in our matter.
So to have clarity, Mr. Sibal, you say that, well, ask this Speaker to decide the disqualification of the 39 MLAs. Ask him to do so within a stipulated period. We will then challenge. There are 2 options. The Speaker may come to the conclusion that they are disqualified. Then what happens?
Then what happens?
These 39.
They will come, Mullah. They will come in appeal.
No, but then how does that affect, what is the consequence practically in terms of the trust vote which takes place?
Well,
The Speaker, all right, assuming that the court has the power.
The Chief Minister will go. The Chief Minister will go.
How?
But 164(1)(b), he cannot hold office. 1 second, hold on.
"39 people will go out if the
And he
speaker
will not be able to
disqualifies
be
them."
chief minister. He will not be chief minister.
Well, 39 people then, if your argument is right, if the speaker holds that, well, they're not disqualified, then you have a right to challenge that order before an appropriate court.
Not appropriate before your lordship.
Fair enough, whatever. If the speaker comes to the conclusion that there is a disqualification, those 39 persons go. In this case, according to Eknath Shinde also, therefore, has to move out.
Yes.
Then what is the next? What is the sequita?
Nothing, then whoever is the chief minister will get back on the trust vote. We'll see about that.
Yes, sir.
We'll This court's order on 29 said trust vote is subject to these petitions.
See, the question put to you is,
All proceedings, Manoj, all proceedings. But this is the problem, Manoj. The judicial orders are passed, we are put in this situation, then we are asked what can we do now?
No, we are not saying what can we do.
Yes,
We
your
are,
lordship,
we are, we are,
what
we are
will
asking you,
happen?
what is your submission on what we can do?
No, Manoj, what your lordship have put
Mr.
it to
Mr.
me.
Sybil, ultimately, you are arguing a constitutional point, but we have to also factor relief which a constitutional court then should give or is capable of granting within the format of the constitution to take the argument to its logical conclusion. So we are not for a moment saying that your argument is incorrect. What we are trying to do now is to test what are the limits of your argument.
As I told you,
How
Lordship,
far does the court
the
go?
limit, your lordship is right. That's why did I say 7 days, Manoj? Because your lordship puts it to me, ultimately what should be done. And I said to your lordship, all right, give him 7 days. But then the question will arise, can you issue a mandamus to the speaker to decide within 7 days? And there'll be a constitutional crisis because the speaker will not obey.
that we don't know.
I don't know. It is possible. It has happened before. It has happened before.
Megachandra is the only case where there is a direction for an early disposal of the petition. That's the only exception.
Yes,
And that again got referred to a constitution then saying that you can't direct the.
correct. Normal as
But.
Justice
right,
Nariman's
but it's
judgment.
nice.
The same thing happened. The problem is, sorry. Fundamental issue. We've challenged Muller's decision of 3rd of July. of the speaker. Well, we are the party. That's fundamental before anything is done by the speaker. So your lordships will, my respectful, please consider the decisions and then whatever the outcome is, let the outcome be. But a shortcut of this nature Let me finish that first. So I was on item 47, Mulad.
Yes.
Now 48. As the delinquent MLAs of SSLP voted against the party whip on 2nd of July issued regarding the election of the office of the Speaker, fresh disqualification proceedings were initiated against the delinquent MLAs as per the provisions of 21B of the 10th schedule. Because they voted against the party whip, so all 39 were involved there. So 16 earlier, then on the 27th, the balance 22, for which notice has not yet been issued, and all 39 now. Because this is 21B, that's 21A. And even for this, notice has not been issued.
So this 3rd July was issued against how many you said?
39.
39.
Under 21B
21B.
for violating the whip. And 21A, I'm sorry?
Fresh one.
Fresh one. 21A, 16 earlier, for which notice was issued, and 22 later, for which petition was filed, but then, of course, next day was the trust vote. I mean, there was a decision, and therefore no notice has been issued here. Even now, no notice has been issued. So those are all pending.
And now the 39.
Now the 39.
Speaker.
That's correct. That's correct. So, and the election of the Speaker was held in complete violation of the provisions. Certain MLAs submitted a letter notice to the Principal Secretary Maharashtra to move a resolution for removal of Rahul Narvekar from the office of Speaker under 179. This is the tit for tat bullets. This is not an argument that I wish to make, bullets. On 3rd of July 2022, just after being elected as the Speaker of the House, Narvekar entered the political thicket and issued a communication late in the evening on 3rd of July, illegally recognizing Bharat Gogavale as the chief whip and Eknath Shinde as the leader of the party. On how basis did he do that, Maharaj? This is under challenge. Under which power did the Speaker do that? Your Lordship knows, Maharaj, this has to come from the political party. Leader of the House has to come from the political party that he is our leader of the House, Maharaj. That letter is written by the Speaker, Maharaj. For example, recently, when Mr. Kharge became the leader of the Congress party, it is Mrs. Gandhi who wrote a letter saying that now, instead of Ghulam Nabi Azad, Mr. Kharge is the leader of the party. I have the letter with me. So on what basis did the Speaker do it? The aforesaid communication of the Speaker of 3rd July was challenged by Sunil Prabhu before this Honorable Court, wherein the Honorable Court, by order dated 4/7 in writ petition, directed to list the writ petition along with other connected writ petitions. So that's also pending. Then 4/7, as the Speaker has misconducted himself by entering into the political thicket and attempted to recognize Bharat Gogavale as the chief whip of the Shiv Sena, certain MLAs submitted a notice to the Principal Secretary Maharashtra Legislative Assembly to move a resolution for removal of Narvekar from the office. Then on 4/7, the confidence motion was called for on the floor of the Maharashtra Legislative Assembly by Eknath Shinde on 4th of July. Confidence motion was carried out in favor of Eknath Shinde. Again, several MLAs of the Shiv Sena voted contrary to the whip issued by the official chief whip of the Shiv Sena. 4/7/2022, Bharat Gogavale, and when your lordships will see the petition before the Election Commission, till the 18th of July, there is no reference to any meeting of any political party. So all this was happening outside the political party. Bharat Gogavale also filed disqualification petitions against 14 MLAs under the 10th schedule for the alleged breach of the whip issued by him. It is submitted that Bharat Gogavale has not been authorized by Shiv Sena political party to issue whips on behalf of the Shiv Sena. 5/7/2022, since the delinquent MLAs of the SSLP has openly defied the whip dated 2/7/2022 in the floor test, confidence motion held on 4/7, Sunil Prabhu has filed fresh disqualification petitions against 39 delinquent MLAs seeking their disqualification under 2(1)(b). Then 7/7/2022, Uddhav Thackeray, in his capacity as president of Shiv Sena, wrote a letter to the speaker objecting to the illegal recognition of Bharat Gogavle as the whip of the Shiv Sena and reiterated the decision of the Shiv Sena political party to recognize Sunil Prabhu as the whip of the SSLP. So, Malas, what's happening here is, Malas, that the legislative party, a majority in the legislature of the Maharashtra Legislative Assembly, is treating itself as the political party and making orders for its own benefit. That's the constitutional issue that your lordships will have to decide.
But who represents the political party is
as I said, Malas, the two offices, Malas, that is the leader of the three offices, Chief Whip and Whip, are appointed by the political party and conveyed to the Speaker.
the Chief Whip and
the Deputy Whip.
the Deputy Whip.
So these are offices, Malas, that are bridge between the political party and the
And
legislative
then
party.
according to you, who determines who is the political party?
I'm sorry?
Who determines who is the political
There's no
party?
challenge here.
No, I mean, ultimately, who is entrusted with the authority to decide?
They have to have a split in the party first. Otherwise, how do you determine under the 10th
But
schedule?
if there is a contest on who represents the political party, who will decide?
There's no contest, Malas. This is not their case. Malas, please appreciate. Till all this is happening, it is not their case that there is a split in the political party. It is nobody's case.
No, but
They say they are the Shiv
there are
Sena.
facts here, but who will then have the authority to decide who is the political party?
That's right. Now you go, what you do is call a meeting of the political party. Supposing, Malas, let's forget about the 10th schedule. Let's not talk of the 10th schedule. Malas, I happen to be a faction in the party, and I say, look, actually the majority of the party is with me. So I can requisition a meeting of the party. Forget the 10th schedule. And Malas, after a requisition meeting in the party, Malas, I take over. So I am the party. By majority, I take over.
Against you.
And there's nothing to do with the 10th schedule. I'm not talking about the 10th. I'm sorry.
Test as they have said.
Sorry.
The test in Sadiq Ali.
Test in Sadiq Ali is nothing to do with this issue, Malas. That's not, I'm not talking of the 10th schedule now. I'm talking generally how a faction in a party can take over the party. Forget the 10th schedule. Now, let's forget that 1985 10th schedule was not there. Then also this question would arise. But this question would arise only if there is a division in the legislative party. Dehors the 10th schedule. I hope, Malas, I made myself clear. Dehors the 10th schedule, this question can arise. That people in the legislative party can say that, look, no, we don't agree with your policies. Let's call a meeting of the party. Right? In that meeting, Malas, they feel that they are a faction who are entitled, Malas, to the symbol of the party. They want to set up a separate party. Right? They can go and say that we, the legislators, along with the organizational structure, are the party, separate party. Give us the symbol. We are the majority. Forget the 10th schedule. It can happen even out, but that can only happen if there's a split in the legislative party. Correct, Malas? It can only happen then. Otherwise, it's a normal procedure of taking over the presidentship of the party. Sadiq Ali, the same thing happened. There was a split in the legislative party and the political party. And in Sadiq Ali, they said that, look, as far as the organizational structure is concerned, on both issues, they are entitled to, the other side is entitled to the symbol. That's fine, no issue. Here, Malas, this split should have happened on the 21st of June. There's nobody's case in the political party. Why? Because para 15 of the 10th schedule says that if there are two factions, and the symbols order says, if there are two factions resulting from a split in the political party, then the question of symbol will arise. Right, Malas? It is nobody's case here. Nobody has, they say they are the Shiv Sena. Why? Because they are 40. So how does a majority on the legislative assembly become the Shiv Sena? Then, Malaj, if in the Congress in Goa, if majority of the Congress legislators join, as they do, Malaj, I have been seeing this happen again and again, Malaj, then they are the Congress. They can say they are the Congress. But how can they say that? Therefore, Malaj, this has grave consequences on the polity of this country. Because now the legislative party seems to believe that it can, under the 10th schedule, proclaim itself to be the political party and throw out office bearers who are appointed by the political party in the House. Constitutionally, that cannot be countenanced. Who appoints the leader of the House? Says, in exercise of my power as chairperson of the Congress Parliamentary Party, I hereby make the following appointment to the Rajya Sabha. Shri Kharge, MP leader of the Congress Party, against the vacancy of Ghulam Nabi Azad, whose term in the Rajya Sabha has come to an end on 15th February. This is a letter written by the Congress UPA chairperson to the Speaker, to the chairman of the Congress or the Rajya Sabha. That's how Malaj people are appointed. Can Malaj, Mr. Kharge on his own, or could he have said that I am the leader? I have so many MPs, so I am the leader? The same thing with the whip. Now, Malaj 57. The newly elected speaker in an illegal, arbitrary, and blatant display of malafide. And how do you, Malaj, allow this speaker to decide this matter when he's been doing these things? Your Lordship, Malaj, has great, what should I say, confidence in the constitutional office of the Speaker, Malaj. Great confidence. But do they discharge this confidence?
But that confidence you also have when you say that that speaker had to decide a disqualification petition.
Yes, correct,
And
Mother.
that is not
It'll be subject to challenge. It's subject to challenge.
Right, and that is not dependent on who is the speaker, Mr. Siddharth.
No, Malaj, I'm sorry. That speaker did not do anything like this, Malaj. You have to now see, kindly see, look what is happening.
But the constitutional authority of the speaker to decide is not based on who the speaker is, on what decisions he will take.
Can ever a finding of bias be reached by a constitutional court? You Lordships will say no. Let's put it another constitutional issue. If a constitutional authority has so conducted itself that a constitutional court comes to the conclusion that such a constitutional authority cannot discharge the functions that it is discharging because of its open bias, your Lordships will say no, we let them decide. I don't know, Malad. I don't have the answer for it.
No, not necessarily. In Rameshwar Prasad, with respect to a governor,
Governor, yes.
judgment of this court that if there is an allegation of bias, then government has to come and defend it.
Malad, that's exactly.
It's possible, not that the court will naturally do it, but then we all are proceeding on the premise that, in fact, your argument had been in the first part also, that so far as the speaker is concerned, it's a constitutional authority.
No, but see what he has done. He has appointed the whip. He has appointed the leader of the house. What kind of confidence can we have in this constitutional authority? Who, without reference to the political party, is doing all this? Do you think he can ever decide in my favor? There is no way.
But then you have the first speaker who, in defiance of the legislative rules, gives 2 days notice.
I'm sorry. No, that is.
In defiance of the legislative rules, gives 2 days notice.
That your Lordship.
Yeah, all this is the way everybody is behaving.
And that's correct. So what do we do, Manoj? Your Lordship will then have to.
There are two options. Either you debunk the authority of the speaker, or you say,
I said that on day one,
Manoj. Alternately, irrespective of what lesser mortals decide, ultimately, in a democracy, you value the office or the institution.
Then that 27th order should not.
If we say.
Correct, then the 27th order should not have been passed.
Denigrating constitutional officers, including the office of a speaker.
Well, they are denigrating themselves. They are denigrating themselves. We are not denigrating.
No, Mr. Sibal, there's some problem.
It's a race to the bottom then.
Yes, we have. We have to start Mullad's what to do. But the problem is, Mullad, that problem is very serious. And therefore,
It is they are the legislators, parliamentarians who have decided upon the speaker to be the tribunal for 10 schedule. It is parliamentarians' decision.
I agree.
Then
Mulad.
schedule. So therefore, court is only interpreting that.
Fine, Mulad. Then we must go back to
This doesn't
27th.
take us anywhere, Mr. Sibal. The difficulty, repeatedly you say, at one stage, it poses a very big problem for the court.
Yes.
On the one hand, if the speaker is with you, you would say that it's a constitutional authority. What's wrong with the speaker? If you have some difficulty, you would say, you means not you. You would say, look at the way the speakers have behaved. So therefore, for us, as long as the Constitution bench judgment is there, we will go by the fact
I
that
agree.
the speaker is the tribunal and he is the presiding officer for 10th schedule.
Correct.
And
Correct,
we will not go back the decision. That's the final decision so far as we are concerned.
Fine. That's, I mean, I don't
Proceed.
want to, Mulad, say anything contrary to that, except that on that logic, the 27th order could not have been passed.
You will argue that.
Then we come back to that. Mulad. And that's what led to where we are today.
And again, it's merely because one or two speakers have gone astray. Would the court be inclined to debunk the whole procedure as laid down and the 10th schedule?
No,
by
no,
saying-
Mulad, I mean, my intention is not that. I'm just, Mulad, telling your lordships what has been happening.
So it's a conundrum.
Yes, it's a conundrum. It's a constitutional conundrum, but your lordships will one day have to sort it out.
Sorry for another question. Every time this question is raised before the court, I would want to ask you, how many times did the parliamentarians raise this question in the parliament saying that let us actually amend the constitution, change the speaker? How many times the discussion took place in the parliament to review the conduct of the speaker? Why is that question raised before the court, which is not the forum for consideration? How many times the parties have sat down together and decided that this is not working? Let us go back.
Once the Kyoto Holohan was rendered, Mulad, what would Parliament would say?
Why it only upheld the 10th schedule. It is you making the 10th schedule.
No, Mulad, the political party in power, wherever it is, wants to use the office of the speaker to do what they are doing. The political party would never, in power, would never like to change it.
This will take us nowhere, Mr. Sibal, frankly, and this will, unless there's an amendment to the constitution, unless there is a reference, a direct challenge. And so
Justice Sabharwal
we
said
have
it.
to proceed on that premise.
Justice Sabharwal said it in a judgment of this court, Jagjit Singh. Exactly that. Undoubtedly, our constitutional scheme, the speaker enjoys a pivotal position. The position of the speaker is and has been held by people of outstanding ability and impartiality, without meaning any disrespect for any particular speaker in the country, but only going by some of the events of the recent past. Recent past. Certain questions have been raised about the confidence in the matter of impartiality on some issues having political overtones, which are decided by the speaker in his capacity as a tribunal. It has been urged that if not checked, it may ultimately affect the high office of the speaker.
Correct.
Our attention has been drawn to the recommendations made by the National Commission to review the working of the Constitution, recommending that the power to decide on the question as to disqualification on the ground of defection should vest in the Election Commission. I dread that as of today, Mulad. Election Commission instead of the Speaker of the House. Concerned. Our attention has also been drawn to the views of a number of other experts, committees, commissioners, to the effect that power of disqualification as a result of defection needs to be exercised in accordance with the opinion of the Commission, as in the case of decision on questions as to disqualification of members. Whether to vest such power on the Speaker or Election Commission or other institution is not for us to decide, as your Lordship rightly said.
Exactly.
It is for Parliament to decide.
Exactly.
Right, I agree. I'm not disputing
will be
that. But I'm just saying the disquiet that we have witnessed in the functioning of the office, that's all that I'm saying. I'm not saying this person is good or that person is good. It's the institutional framework within which he functions, Mulad, is not consistent with his responsibilities as a tribunal. That's all that I'm saying. What to do? But the fact is that he had no authority in law to decide on the whip and on the leader of the House. That's not his.
That's a separate issue. We made it out of that.
That's why I make that argument. Then let's come to the newly elected speaker in an illegal, arbitrary, and a blatant display of malafide and bias issued notice to 14 MLAs seeking their response to disqualification petitions filed by Bharat Gogavle. The speaker is still sitting tight on the disqualification petitions filed by Sunil Prabhu and has not even issued notice in them despite their disqualification petitions being filed much earlier. He issues notice on their disqualification petition, but not on ours. And they haven't filed a reply. This court said in the interim, we adjourn it to 12th of July. From July, we are in February. Where's the reply? "18th of July, the notice issued by the Speaker in the disqualification petitions filed by Bharat Gogavle against 14 Shiv Sena MLAs, including Sunil Prabhu, was challenged by Sunil Prabhu in writ petition, wherein this Honorable Court, by order dated that, directed to tag the writ petition along with other connected matters." So that's also before your lordships. And now, the Election Commission says they are the Shiv Sena. Now we'll be further disqualified. Any meeting called, if we don't attend, then when we are, then it'll be further problems. Despite the fact that this Honorable Court is seized of the issues regarding disqualification of Eknath Shinde under the 10th schedule, Shinde filed a petition before the Election Commission under para 15 of the election symbols reservation and allotment order to declare the splinter group led by him as the Shiv Sena. So this is the first time that he went. On 20th July, by order dated 20th July, another in writ petition so-and-so, another connected petition, this court issued notice in writ petition so-and-so. It was directed by this Honorable Court, the writ petition shall be treated as the lead matter. 20th July, pursuant to the order of the court dated 20th July, Shri Subhash Desai made a representation to the ECI, by representation requesting ECI to not proceed with any petition related to Shiv Sena, as substantially similar matters and issues are pending before this Honorable Court, and not to take any preemptive action. Then IA 100285 was filed on 21st July, was preferred by Sunil Prabhu in writ petition seeking direction to the Speaker, Maharashtra Assembly, to produce the following records. All proceedings relating to disqualification of rebel Shiv Sena MLAs filed by Sunil Prabhu, all proceedings related to disqualification filed by Shri Gogavle, all proceedings of the Speaker and Deputy Speaker in relation to recognition of the Leader of the House and Chief Whip of Shiv Sena, proceedings of the House on 3rd July and 4th July. 22nd July, without deference to the proceedings pending before this court, as well as without considering that no adjudication can take place till disqualification petitions pending against delinquent MLAs are decided, Election Commission issued notice to Uddhav Thackeray on the petition filed by Eknath Shinde. And on 25th July, agreed by the issuance of the notice by the Election Commission, in Shinde's petition, Subhash Desai was filed 2 applications, IA so-and-so, seeking impleadment of Election Commission of India as respondent 51 and writ petition so-and-so, and seeking stay of proceedings initiated by the Commission on 22/7 till the final adjudication of the present petition. On 4th of August, this court, after hearing the Election Commission and the parties, recorded the submission of the Commission that no orders may need to be passed by this court interdicting proceedings before the Election Commission. Liberty was granted to the petitioner to file an application before the Election Commission for seeking time. Accordingly, 6th August, petitioner in terms of the order of 4th August filed an application with a prayer to defer adjourn the proceedings in dispute on dispute number 1 of 2022 for 4 weeks and extend the time for filing a response for 4 weeks. 10th August, Election Commission communicated to the petitioner extending time. 23rd August, Honorable Court, by its order, held that the present batch of petitions raised important. Then those questions were, then your lordship straight come to 23rd August, made a request on the very same day to the Commission to defer proceedings. Then this went on, and on 22nd of September, a further request was made by the petitioner to the Commission for deferment of proceedings by 2 weeks, till this court decides the question as to whether proceedings before the Commission should go on. And then 27 December, your lordships, dismissed the application. So that created another problem, because the Election Commission decided the matter, dehorsed, these pending proceedings. And on the basis of that majority in the Legislative Assembly has given them the symbol. Well, that very majority is subject of disqualification petition. So we have another problem. And we went to the commission and said, please await the decision. The Supreme Court did not stay, it didn't stay the proceedings, but the Supreme Court did not say that you decide it on merits based on majority in the Legislative Assembly. Because those disqualification petitions are pending. But he said, no, Supreme Court has said no stay, so I will decide the entire matter. That's the other problem that happened. Because I never thought your lordships meant stay of proceedings only meant that you decide whatever the matter is, you hear the arguments, decide on law, on the submissions made, but they took it. The High Court also took it the same way. We went to the High Court also. They rejected it, saying your lordships have said no stay. Therefore, the commission can decide what it likes. And I told the commission that, look, if supposing you give this symbol to them based on this majority, and ultimately they are disqualified, then what happens to the symbol? Will we get back the symbol? So, you have another problem on our hands. So anyway, only your lordships can decide this matter. We can only place the facts before you. You have to do something to be able to ensure that there is confidence in institutional frameworks in the system, in this country. That's my only concern. Winning or losing doesn't matter. These are political battles. Will be won today and lost tomorrow, or lost today and won tomorrow. But the institution must go on, and the people of India must have confidence in that institution, whether it's the Election Commission or the Office of the Speaker or the court. Nonetheless. Then we come to 4th October, Eknath Shinde filed an application before the Commission under para 15 of the Symbols Order to urgently hear, dispose of, and allow the petition filed by Shinde under paragraph 15. On 7th October, Thackeray filed a preliminary reply to the application under para 15 with a prayer requesting Commission not to pass any order without an opportunity of oral hearing to Thackeray. Well, on 8th October, Thackeray filed a reply to the application of Shinde under para 18 of the Symbols Order. Election Commission without hearing either of the parties. This is another curious thing. On 8th October, without hearing either of the parties, and merely hours after the reply of Uddhav Thackeray was filed, passed an order in dispute 1 of 2022, inter alia freezing the symbol of bow and arrow. And your lordship knows, Malas, that a hearing is required. It's mandatory under paragraph 15. Also, the Election Commission directed Uddhav Thackeray and Eknath Shinde to first furnish their preferences for interim party names and interim symbols. Uddhav Thackeray, under protest and without prejudice to his right to challenge the impugned order, freezing the symbol bow and arrow, proposed 3 interim names and interim symbols of his own choice in the order of preference. 10th October, Shinde proposed his preferences of symbols, out of which first 2 were identical to the interim symbols proposed by Uddhav Thackeray. The first interim name proposed by Shri Shinde was also identical to the first interim name proposed by Thackeray. On 10th October, Election Commission rejected the first 2 interim symbols proposed by Thackeray on the basis of Shinde had also proposed. Due to some same reason, Shri Uddhav Thackeray was denied the interim name Shiv Sena Balasaheb Thackeray. On 10th October, agreed by the arbitrary freezing of symbol without affording an opportunity of oral hearing, by order dated that passed by the Commission. In dispute 1 of 22, Uddhav Thackeray filed a writ petition in the High Court of Delhi, seeking inter alia to quash the aforesaid order. Election Commission allotted the interim name Balasaheb Banchi Shiv Sena to Shri Eknath Shinde and requested Shinde to furnish a fresh preference list of symbols. 11/10, Eknath Shinde submitted a fresh list of preferred symbols. Election Commission allotted the symbol of Do Talware or Ek Dhal to Shri Eknath Shinde. The present batch of matters was listed before the Constitution Bench for directions on such and such day. Then Miller's Election Commission addressed a letter to Uddhav Thackeray and Shinde asking to submit all the details, particulars, documents to dispute 1. And the High Court of Delhi it dismissed the petition filed by Uddhav Thackeray.
Yes. We'll have
Yes, DB also.
the date of the decision. Yesterday or day before, election commissions?
Now the election commission.
Yesterday.
17th of October.
Yesterday, day before.
17th February. So that's the really list of dates and the list of events. Having said that, just let's go to the 10th schedule straight away.
Yeah.
In this schedule, unless the context otherwise requires, house means winter mode, Malas.
Summer has come early.
Yeah. Must come very early this year.
Unless the context otherwise requires, house means either house of parliament or the legislative assembly, or as the case may be, either house of the legislature of a state. Legislature party in relation, just to have the facts straight, Malas, out of 55, 38 are with them in the Maharashtra Legislative Assembly, right, Malas? And in the Lok Sabha, out of 18, they allege that 13 are with them, but they have filed affidavits of 12. The Legislative Council, Malas, in Maharashtra, all of them are with us. All 12 are with us.
12 out of 12.
All of them are with us. And in the Rajya Sabha, 3 out of 3 are with us. And in Lok Sabha, 6 are with us, according to us.
Mr. Sibal, will you repeat the numbers?
Yes. In the Legislative Council in Maharashtra, all 12 are with us.
1 second.
All 12 are with us. But in the Legislative Assembly, Malas, 38 are with them. You say 40, but they have affidavit of 38 only. It's all right. I mean, you can say 40. I don't mind. I mean, yeah, it's all right. 40 and 15 with us. Doesn't matter. In the Rajya Sabha, all 3 are with us. And in the Lok Sabha, whereas out of 18, they are 19. 13 are with them and 6 are with us. So it's not as if, Malas, it is some overwhelming majority with them. And in the organizational structure, and what
about the Rajya Sabha?
Lok Sabha
three Rajya Sabha are all with us.
and Lok Sabha.
Legislative, Lok Sabha, Manas, 6 are with us out of 19. Yeah, out of 18. So in 2 houses, they have majority. In 2 houses, we have majority. But be that as it may, Manas, the issue is ultimately not that. But just so that your lordship knows, Manas, in the organizational structure, the other surprising thing is, Manas, we both argued on the Constitution of 2018.
What is the organization?
On
What is
the
the
Prathinidhi
structure of
Sabha,
organization of
there is a
Shiv Sena?
Prathinidhi Sabha and there is the Karyakarani, which is the executive, largest executive body, 13 members of the Karyakarani, and
General
about
bodies,
260 odd members of the Prathinidhi Sabha, which will come to later. The point that I'm making is that we both relied upon the 2018 Constitution. But the Commission, in its order, without letting us know during the argument, said that the 2018 Constitution is not recorded in the Election Commission. Never put it to us, never told us, not their argument, not my argument. Both argued on the 2018 Constitution, and the Commission, without ever informing us, says that Constitution is not on our record. Anyway, but that is it. Anyway, so even though we have majority in the organization, they say we will not consider that. So they don't consider the organization, they consider these majority of those who are, according to us, disqualified, and give them the symbol. So you move from the speaker to the election commission, and then from there, where do you go? Anyway, so let's now come to the tension. B, legislature party in relation to a member of a house belonging to any political party, in accordance with the provisions of paragraph 2, or 4, means the group consisting of all the members of that house for the time being belonging to that political party, in accordance with the said provisions. Your Lordship sees the symbiotic relationship between the legislative party and the political party. The original political party, in relation to a member of a house, means the political party to which he belongs for the purposes of subparagraph 1 of paragraph 2. Paragraph means paragraph in this schedule. Then 2, subject to the provisions of paragraphs 4 and 5, a member of a house belonging to any political party shall be disqualified from being a member of the house if he has voluntarily given up his membership of such political party, or if he votes or abstains from voting in such house contrary to any direction issued by the political party to which he belongs, or by any reason, or by any person or authority authorized by it in this behalf, without obtaining in either case the prior permission of such political party, person or authority, and such voting or abstention has not been condoned by such political party, person or authority within 15 days from the date of such voting or abstention. So, what's important here to note is that he cannot vote contrary to any direction issued by the political party. So, obviously, in terms of paragraph P, it's the political party which issues the direction, not the legislative party. And the direction is issued through the leader of the political party, normally the whip, or the leader of the political party. Such person authorized. So therefore, the political party will authorize such person, and he is the whip. The whip term is not used in the 10th schedule, as you will notice. The term used is direction. Or by any person or authority authorized by this behalf, without obtaining in either case the prior permission of such political party. Normally, whose permission has to be obtained if I want to vote against the whip? Political parties. And political party is outside the house, not within the house. Within the house are only legislators. So you'll have to go to the whip, you'll have to go to the whip, or the person authorized, look, I want to vote against, or I want to make a speech against. I don't agree with this bill. And sometimes, actually whips do agree. It has happened so often with us. You say, no, these particular clauses, I don't allow me to speak, but I will vote for you ultimately because I don't want to violate the whip, but allow me to speak. And sometimes we are allowed. Then let's kindly come to the explanation. For the purposes of this subparagraph, an elected member of a house shall be deemed to belong to the political party, if any, by which he was set up as a candidate for election as such member. A nominated member of a house shall, where he is a member of any political party on the date of his nomination, as such member, be deemed to belong to such political party. In any other case, be deemed to belong to the political party of which he becomes, or as the case may be, first becomes a member before the expiry of 6 months from the date on which he takes his seat after complying with the requirements of 99, or as the case may be, Article 188. So a nominated member within 6 months actually can join a party, but not after 6 months. Then subsection 2 is very important. An elected member of a house who has been elected as such otherwise than as a candidate set up by any political party shall be disqualified for being a member of the house if he joins any political party after such election. I belong to that category. So, Malad, if I try and join any other party, Malad, I shall be disqualified.
Anglo-Indians.
That's right. That's for nomination, Malad, not.
3.
Yes. 3 is a nominated member shall be disqualified being a member of the House if he joins any political party after 6 months. That's what I told your lordships. From the date on which he takes his seat after complying with the requirements of 99. Notwithstanding anything contained in the foregoing provisions of this paragraph, a person who, on the commencement of the Constitution, is a member of a House, whether elected or nominated as such, shall, where he is a member of a political party immediately before such commencement, be deemed for the purposes of subparagraph 1 of this paragraph to have been elected as a member of such House as a candidate set up by such party. In any other case, be deemed to be elected. This we don't really worry about. Para 3 is now deleted, Malad. Now, Malad, let's see what para 3 said. The lordships will find that in statutes, Malad. Statute item number 3. Let me just take it out.
Page 48, it's there. PDF 50.
Yes, PDF page 50.
50.
Yes. Worship has that?
Yes.
Yes.
Got it?
Hello, Justice Shah has it? Now, disqualification on account of defection not to apply in case of split. Where a member of a House makes a claim that he and any other members of his legislature party constitute the group representing a faction which has arisen as a result of a split in his original political party. And such group consists of not less than 1/3 of the members of such legislature party, he shall not be disqualified under subparagraph 1 of paragraph 2. So paragraph 3 as it then stood operated on the assumption that there is a split in the original political party. A split in the legislative party would not have been a defense, even if it is more than 1/3.
There has to be a split in the original political party.
Now, how does that split happen? Because he makes a claim. Before all this happens, demonstrates in the claim that a split has occurred, calls for a meeting of the original political party, has a faction, has a resolution passed, breaks away, Malaj, and then if he is 1/3, it's a defense. Even if he loses Malaj in capturing the party, he shall not be disqualified under paragraph 2 that he is voluntarily, sorry, Malaj, where was I? Yes, that such group consists of not less than 1/3 of the members of such legislative party. He shall not be disqualified under subparagraph 1 of para 2 on the ground that he has voluntarily given up his membership of the original political party, or that he has voted or abstained from voting in such house contrary to any direction issued by such party, or by any reason or authority authorized by it in that behalf, without obtaining the prior permission of such party, person or authority, and such voting or abstention has not been condoned by such party, person or authority within 15 days from the date of which such voting or abstention. And from the time of such split, such faction shall be deemed to be the political party to which he belongs for the purposes of subparagraph 1 of 2, and to be his original political party for the purposes of that paragraph. So the splinter group of that party can be a separate political party. He will, because he is 1/3 in the legislature, belong to that party, because that becomes his original political party. None of this has happened here.
The quantum of the split, interestingly, was not defined in terms of numbers. So long as there is a split, The 1/3 is in relation to the group representing the legislative party.
Legislative party. not-
Yes, yes, I agree, Madam. Well, that split may be minority, majority, it doesn't matter.
So long as, there is a split
There is a split.
in the original political party.
Correct. So that's not the case here, Malad. On 21st of June, they were in Gujarat and they were in the Northeast, only the legislative members. And they never said there's a split. They said, we are the Shiv Sena. So that claim was also not there. Then came the 91st Amendment, Malad. 2003. Sorry, 2000. 1st January 2004. No. Yes. It's an act of 2003, but came into force on 1st January 2004. Then
Yes.
now, let us kindly see this constitutional amendment. They amended 164 of the Constitution, which you will find, Malad, in PDF page 52. In Article 164 of the Constitution, after Clause 1, the following clauses shall be inserted.
Where are we?
Well, is that PDF page 52?
PDF page 52, yes.
Well, this is the amendment starts, Madhur, at PDF page 51. And the relevant part, because 1A and 1B were added. And if you see section 3 of that, in Article 164 of the Constitution, after Clause 1, the following clauses shall be inserted, namely 1A, the total number of ministers, including Chief Minister and the Council of Ministers in the state, shall not exceed 15% of the total number of members of the Legislative Assembly of that state, provided that the number of ministers, including Chief Minister, shall not be less than 12. Provided further that the total, we are not concerned with that. 1B, Maharaj. A member of the Legislative Assembly of a state or either house of the legislature of a state having legislative council belonging to any political party who is disqualified for being a minister of that house under paragraph 2 of the 10th schedule shall also be disqualified to be appointed as a minister under clause 1 for duration of the period commencing from the date of his disqualification till the date on which the term of his office as such member would expire, or where he contests any election to the Legislative Assembly of a state or either house of the legislature of a state having legislative council, as the case may be, before the expiry of such period till the date on which he is declared elected, whichever is earlier. This also creates a lot of problems. That problem doesn't confront us in this case, because most of these people then resign, join the other party, get elected, become minister. So there is some scope for challenge to this particular provision, its constitutionality. But be that as may, we are concerned with the earlier part of this, that if you are disqualified, you can't be a minister. Now, your disqualification is pending. Matter is before the Constitution bench. Matter is before the Speaker, whichever it may be. And you are appointed by the governor.
And also there's a provision under the Representation of People's Act where they can't contest again.
That's right. Not for this, Malas. Not for the 10th schedule. That is for other corrupt practice. There's no period here. That's why I say this is subject to challenge.
Right.
Okay.
There, if you for all kinds of other reasons, corrupt practice, and he's been convicted for X number of years. Now, what is happening in a ordinary case of a dharna on a road, a trial court convicts you for 2 years and you lose your membership of the Legislative Assembly. That's also happening. We can see it, headline news everywhere. What do we do? Can't keep on coming to court every other day. Your lordships also get fed up with us. Sorry.
Already.
How many times do we give you justice? Now, kindly now come. So, therefore, now the bottom line is there is no concept of a split anymore. Then the statement of objects and reasons for deletion of the paragraph at PGF page 54. That says para 2, the Committee on Electoral Reforms. Demands have been made from time to time to certain quarters for strengthening and amending the anti-defection law.
Where are you reading?
At PDF 54, the objects and reasons of the deletion. Yes. May I read that, Malas?
Yes.
Yes.
Demands have been made from time to time in certain quarters for strengthening and amending the anti-defection law as contained in the 10th schedule to the Constitution of India, on the ground that these provisions have not been able to achieve the desired goal of checking defections. The 10th schedule has also been criticized on the ground that it allows bulk defections while declaring individual defections as illegal. The provisions for exemption from disqualification in case of splits, as provided in paragraph 3 of the 10th schedule to the Constitution, has in particular come under severe criticism on account of its destabilizing effect on the government. Please see this, please mark this. The purpose of the amendment is that we will not allow you to destabilize the government by bulk defection. And that's exactly what has happened here. So you have to interpret the 10th schedule and its provisions to ensure that there is no bulk defection. And the concept of minority is over. Bulk majority also will be subject to disqualification. And 1/3 was a defense. Majority is not a defense anymore. There is no defense as far as a split is concerned in the legislative party. That is not necessary. Well, as paragraph 2 there, the Committee on Electoral Reforms, Dinesh Goswami Committee, in its report of May 1990, the Law Commission of India on 170th report on reform of electoral laws, 1999, and the National Commission to review the working of the Constitution, in its report of 31st March 2002, have inter alia recommended omission of said paragraph 3 of the 10th schedule to the Constitution pertaining to exemption from disqualification in case of splits. The NCRWC is also of the view that a defector should be penalized for his actions by debarring him from holding any public office as a minister or any other remunerative political post for at least a duration of the remaining term of the existing legislature or until the next fresh elections, whichever is earlier, it is proposed to accept these suggestions.
Mr. Sibal, notwithstanding the deletion of paragraph 3 of the 10th schedule, the issue as to who represents the political party is still a moot issue.
No,
But that has to be resolved outside the legislative party. That cannot be still, according to you, resolved within the fold of the legislature party.
that question doesn't arise in this case because this,
No, I mean, we're not on this case, but that question as to who represents
that will happen outside the House.
that will happen outside the House. That cannot be resolved by the number of legislators within the House.
That's my only submission, Manoj.
Yeah.
How that is resolved outside the House is actually given in a judgment of this court in Brahmanand Reddy.
That's
I'll
a
issue-
matter of the internal, the internal constitution.
That's right, that's right. You have to call a meeting, you have to raise the issues. Manoj, for 2.5 years, the gentleman was a minister.
The procedure, the bylaws of that party.
Yes. You have to follow those bylaws, you have to call a meeting, you have to resolve that issue, and then you can do all this, Manoj, when paragraph 3 was there. Otherwise, Manoj, what you're doing is exactly what the object says you shouldn't allow to do, bulk defections. Toppling the government. As I said, what this would result, if you were to uphold this, Manoj, my humble submission, if you were to uphold this, then any government can be toppled, Manoj, for the simple reason you take those people, become majority, appoint your speaker, Manoj, and have a trust vote and you are in government. You don't need anything else. You don't need to have a split in the political party. That's a matter of Manoj, a dispute that will arise and it will go to courts and the courts will decide in their own time, Manoj. In the meantime, the 5 years will pass. So if you wanted to remedy this menace, you can't allow the perpetuation of this menace by recognizing a split in the legislative party as if there's a split in the political party which is not even addressed, which is not even claimed. What is claimed is that we are the party. Now, we are the party can't be claimed within the legislative party. Well, for 2.5 years, I'm sorry.
For 2.5 years.
He was the minister. This very government never raised any issue. There is no public document saying that he is dissenting or he's a conscientious objector. Nothing. No evidence, no document filed, no evidence of that, no public statement, no newspaper report, nothing. He was the leader of the House till 21st of June. And overnight, Manoj, facts stare you in the face. The only way, Manoj, this is not what Parliament will be ready to do, the only way to remedy this is to have a 5-year period of no public post moment you defect. No minister, no public post, no public sector, no nothing. All this will stop. That's the only way. 164, 1B now gives you a way out. Instead of defecting, you can resign. And then you become minister. You were a minister before, all you have to do is resign. This is the only way. If you want to maintain morality in public life, you will not be given any public office, no governorship, no remunerative post.
Kind of cooling off,
I'm sorry?
cooling off of sorts.
Yeah. Even in 361, Malaj, in fact, disqualification for appointment on remunerative political post. capital B, Malad. If he was disqualified, he can't hold a remunerative post. Actually, 91st Amendment, Malad, was very careful in trying to sort of settle part of the problem. But one thing was clear, they did not allow for bulk defections. Normal is paragraph 4, if I may read, Malad, the 10th schedule. Oh, one, Malad. Just waiting for my lady, your ladyship. Okay. A member of a house shall not be disqualified under subparagraph 1 of paragraph 2, where his original political party merges with another political party. And he claims that he and any other members of his original political party have become members of such other political party, or as the case may be, of a new political party formed by such merger. So, Maharaj, if the Congress or if a small party in a state merges with another big party to form a new party, that becomes his original political party. Therefore, a member of a house shall not be disqualified where his original political party, maybe a small party, merges with another political party, and he claims that he and any other members of original political party have become members of such other political party, that is, they merge into that party, or, as the case may be, of a new political party. Both of them may form a new political party formed by such merger.
So A merges with B, or A and B merge together to form C.
Form a new party. So therefore, no disqualification. It's a merger of the political parties. Or have not accepted the merger and opted to function as a separate group. So I say, look, I don't accept the merger.
There's no compulsion to merge.
There's no compulsion. I may be majority, I may be minority within the legislature.
This will be called the unattached member?
Yes. No, but if he has not merged, he can form a separate. He will belong to the original. Supposing two parties merge and form a new party. Correct, Malaj? And he belongs to the original political party on which he won the election. He will continue to be the original political party.
I think Amar Singh sat like that.
Amar Singh, yes. He will continue with the original political party. That also issue is before the larger bench. So, if there's a new political party formed pursuant to merger, and I belong to the original political party on the basis of which I was elected, I continue to be in that original political party.
But clause 2 now again has
I'm coming to that.
requirement.
Yes, I'm just coming.
It is 2/3 of the existing members of the
That's a very interesting provision, which of course doesn't call for interpretation now, but it has some nuances that's important for us to understand. And from the time of such mergers, such other political party or new political party or group, as the case may be, shall be deemed to be the political party to which he belongs for the purposes of subparagraph 1 of paragraph 2 and to be his original political party for the purposes of this subparagraph. So from the time of such merger, either to a party or to a new political party, he is deemed to be a member of that political party to which he belongs for the purposes of paragraph 1. So may belong to that original political party and is dissociated himself, or after merger he belongs to the other political party. No issue. Now comes the problem. For the purposes of subparagraph 1, of this paragraph, the merger of the original political party or a member of a house shall be deemed to have taken place if and only if not less than 2/3 of the members of the legislative party concerned have agreed to such merger. Now, if 2/3 of the members don't agree, then there is no merger as far as the legislators are concerned. First, the merger takes place. Then the question arises whether you are 2/3 or not. If you are 2/3 and you agree, it is fine. It's a defense. If you are not 2/3, Malaj, then you can be a separate group. So 2/3 happens to be a defense after the merger.
This deemed is also very important.
Yes.
Because what 10th schedule does is that it doesn't create a new category. By saying deemed, it is relating back to the position of the assembly as it were.
Yes.
When legislators got elected and come to the assembly.
Yes.
That position will be deemed instead
Yes.
of creating a new category.
Correct. For the purposes of one, the merger of the original political party of a member of the House shall be deemed to have taken place only if not less than 2/3 of the members concerned have agreed to such merger. So 2/3 of the member, less than 2/3 of member, question defense doesn't arise. But if 2/3 of the members agree, then that's a defense. That's a perfect defense. So, looked at it from any standpoint, these 40 people have no defense under the 10th schedule. They don't claim that there's a merger. They say that they are majority in the legislative party. They claim that because of that majority, they can change the whip. They claim that they can change the leader of the House. They can call themselves, Eknath Shinde can call himself the leader, merely because he happens to be one of 40. And so what happens, to the political party to which he belongs? What morality are we talking about? What conscientious objectors are we talking about? Conscientious defectors is the word that I used last time. And you don't raise a voice for 2.5 years. You are the leader. You enjoy the fruits of ministership. And suddenly you say that, look, now I am free to do what I want. I can join up with the BJP. I can go to Guwahati or wherever I want to go to, and that's it. So the question that your lordships will have to ask, Mullah, how does the 10th schedule come to their aid at all? Under what provision of the 10th schedule can they have a defense? The schedule doesn't give them a defense. Whether it's a minority bulk moving away or a majority moving away. Which is when we last time were discussing this matter, this is what I mentioned. That the 10th schedule doesn't make a distinction between majority and minority. It just ensures that this habit of bulk defections, which is destroying the polity of this country, and by which elected governments can be overturned. So the objective is that you should not allow an elected government to be overturned. That's the fundamental premise on the basis of which paragraph 3 was deleted. You cannot destabilize government. And if you uphold such an act through a judicial process, you are enabling future defections and therefore destabilizing elected governments, which has far-reaching consequences for the polity of this country. That's the issue that your lordships have to decide.
Yes.
Well, it's paragraph 6 of the 10th schedule, but well, I'll take up the next topic tomorrow, well, if you don't mind.
The transcription which we have made was from. Transcription is cleaned up in the early part of the evening. We'll give you a copy so that you can have a look at it if there's something,
You can know what you argued.
Oh, I see. That'd be wonderful.
Don't file an application for amendment.
No. No. Thank you. I appreciate it. I hope you continue to be well. I'm sorry, but